still that does not help me in any way whatsoever, right? So mind it, whatever you present, if you are presenting to your students, if you are referring to any content, literature, images, videos, animation, visual effects you are using, it is fine altogether if it is in the course of the instruction. But if it is beyond that, then mind it, then that you have to be very careful, you have to be very cautious. You should not do that. If you do that, then you never know that tomorrow might you face a copyright infringement suit. Even I may face a copyright infringement suit while using this image, but I was careful while downloading this image. I checked whether somebody has put a copyright on it or not, but I found that this copy is free to, this photograph is free to use, so I'm using it. Then, there are another challenges in the case of, digital dissemination, or in the case of electronic dissemination. It has become very rampant that pictures, images, text, audio, video, these things are imitated unauthorizedly. And sometimes recordings are kept, some links are also given in the presentation, some unlawful appropriation is done. But I told you that all these are problematic if you are not doing in the course of instruction as explained by me. If you are doing it beyond that, then it will certainly land you in trouble. So always be careful while using images or any pictures or text or video, audio, or recording, or a link. Even a link, we provide links. Providing a link is also problematic, because that is also what making the work available. If someone has put his work by a link or through a link, on any of the websites, it is him only who can communicate it to the public. You are not allowed to do so. Well, that is also another interesting slide, which takes us back to the important question. Copyright infringement, or what kind of copying is allowed, to what extent or how much copying is illegal. Is it 10%, 5%, 13%? Is it legal at all to copy, or acknowledging the source is suffice to justify the copying? All these are crucial questions on your screen right now in front of you. Well, so far as the academic institutions are concerned, we have our own policy, IP policy in the academic institutions, or you may say plagiarism policy or similarity policy in other academic institution, where some of the institutions are allowing the research scholars to have 20% similarity or 10% similarity or 30% similarity in their work. But let me tell you, friends and my learned colleagues, this test of similarity is just objective test, right? It does not tell the actual plagiarism. It is a test of similarity, because while you use a software, a technical tool to see the similarity index, it just picks up the similar words, right, and tells you the similarity index. It never tells you anything beyond that. But copyright infringement and plagiarism is beyond that. Copyright infringement even includes taking someone's expression, someone's form. This also is similar, or so is the case of the plagiarism. If you have imitated someone's expression, someone's form of writing, of sequence, of style, that is also copyright infringement. But similarity software can never tell you. It is the job of the supervisor concerned or the mentor concerned to actually identify that kind of a plagiarism or copyright infringement. That can't be found out by merely having a look at the similarity index. But as you know, we have a lot of population, and a lot of works are being created. A lot of scholars are working in different disciplines under different supervisors. So one objective criteria has been brought in, that is of similarity index. But at times the similarity may be very high in a work, and it may not come out to be a plagiarized work. I myself have seen this kind of a situation where the similarity in work of a scholar is almost 20%, where the norm of the university is 10%, but the university has allowed it because on the manual checking it was found out, or it turned out that there is no plagiarism in the work. Just there is a imitation of certain words. If I'm a scholar of constitution law, in my thesis, I will write the word Indian constitution, constitutional law, constitution, of the year 1950, etc. many times, right? Or infinite times. So wherever I write that word, the software will pick it up and tell that it is a similar word used from some source, right? And that is how the similarity will pile up. But that does not mean that I have plagiarized someone's work. So manual checking of the work is the sine qua non, is the only way of identifying whether there's a plagiarism or not, right? This is where, we really face a challenge. And this is where we at times, because of the unawareness and ignorance, don't allow some scholars to you may say, uh, to submit their thesis. But let me tell you that sometimes a work of a scholar whose similarity index is mere 5% can turn out a plagiarized work if he has copied the form, style, or you may say the concept, even the concept of someone else, right? Even that is not permitted, because copyright does not lie, of course, in an idea, but it lies in an expression. And expression is wide connotation, is very broad thing, right? Expression means what? As to how you progress in your work, what all headings and what all subtitles you give into your work, how your work is sequenced. So someone else, if has taken or imitated the sequence, the progression, the style of yours, even that amounts to copyright infringement, right? So I hope you are able to appreciate what I'm saying here. That's why I have written here, is it legal at all to copy? No, it is not legal, and percentage is not the criteria, right? It has to be checked manually. So, and another interesting question, it is usually asked by the audience, whether just by acknowledging the source we justify the copying. No, you don't, because acknowledging does not mean that you can copy someone else's work to whatever extent. For that, we have to refer to the copyright policy of the university, if there is any. If there is no such copyright policy, the law as such does not provide any quantification, but it says that if you have imitated someone's work substantially, then it is copyright infringement. So substantially has to be determined by the a prudent person who is going to be the judge in this case, the judge concerned in the case to decide it. So substantial is also something which cannot be quantified. Substantial, someone's work may be substantial in only 5% of the total work of the person, and someone's work may not even lie in the 95% of that person. So what if you have just taken 5% of that substantial part and has left the non-substantial part, which constitutes 95%? So you plagiarize, right? And you just acknowledge and you go away and walk away free. You can't do that. So in certain countries, there is a norm of even after the acknowledgement of the source, there is a norm of using only 39 words. But in our country, there is no such quantification, because we have used the word substantial copying, and substantial has to be determined in relation to the context, in relation to the subject in question, right? The substantial may lie in 5%, may not lie in the 80% of the work, right? Copied by the person. So that's what I want to say so far as the copyright issue is concerned here. And I believe I have made my case clear. If there are any questions, I am happy to answer. Otherwise, I will move to the next part, where I will be discussing or deliberating on patents quickly in 10-15 minutes. This is what I had to do, because yesterday there arose some interesting questions, and the questions were pioneered and led by Honorable Principal Ma'am, Kiran Ma'am, and some other learned colleagues here. I hope that it answers all the queries which you had.
So there is one, you have said that it means it is a subjective term as far as copyright infringement is there, because you say substantially. So yes, that's one, sir. But sir, my question is, that if plagiarism you are saying, it is you can this is a university purview to decide how much they allow and how much they don't allow. Is it not specified in the law as far as, because our academic
No,
institutions are very much
law does not give any quantification or
of the
quantified test. Law uses the word substantial copying. It while defining the copyright infringement, it says that if someone has copied substantially, then it will be termed as copyright infringement. But
correct, sir. What about plagiarism, sir?
Yeah, plagiarism, there is no definition of the plagiarism provided by the Copyright Act. Copyright Act is silent. Even it does not use the word plagiarism anywhere in the entire legislation, in the entire statute. Copyright and plagiarism are same. Copyright infringement basically is an infringement which is to be dealt under a statute. The plagiarism, on the other hand, is an academic wrong. They are one and the same thing, ma'am. But the plagiarism is academic wrong, where the academic institutions or the universities, they have set certain standards to be followed by the pupil and the faculty over there, right? The law does not specify any quantification or any limit that you can reduce to 10% or you can 20%. These are the standards which are let down by the universities, not by the Copyright Act anywhere. Yes. That's the difference. That's the
So
difference
it means okay, sir.
Yes,
So that means
ahead.
every university have this law in their acts and statutes, right, sir?
Yeah, most of
Not
the
by the law. Yeah.
Most of the universities in India, or sometimes if there is no law made by the university or no policy made by the university, it is the UGC which specifies such norms, right? Which is the highest body for regulating the university affairs. But no institution has no law. The copyright law is the only law so far as this issue is concerned. It does not specify any limit. Not at all. Yes, ma'am. So
Thank you very much.
What I wanted to say is that legally speaking, copyright infringement is a statutory infringement done under the Act, or in the case of plagiarism, which is an academic wrong, where either the disciplinary action is taken by the academic institution in case of violation, or in case of any deviation of the norms of the university, or if the university feels, or any person whose work has been copied, if he feels, then an statutory action under the Copyright Act can also be taken against the university employee or the student for that matter. I hope it is clear, ma'am.
Yes, sir. Yes, sir.
Okay. So that's it on copyright. If there are any questions, I am happy to answer. If there are no questions, then in that case, I would move.
Thank you,
Dr. Ashwini.
Yes, ma'am.
It means usually while our interviews and somewhere we have to see the plagiarism, and the softwares are being launched for that. It means how much is the authenticity of those softwares?
As I told you, ma'am, those are primarily meant to tell the similarity. They are not meant to tell you the plagiarism. And I have given you an example.
Sir, kindly unmute yourself.
I'm sorry, I got muted. I got accidentally muted. I have given an example to you, ma'am. एक स्टूडेंट के वर्क सिमिलैरिटी 25% या 30% हो सकती है, लेकिन जरूरी नहीं कि वो वर्क प्लेजराइज हो. It's not necessary. On manual checking, it may be a case where some common terminologies of the subject are used to that extent कि वो 30% similarity दिखा रहा है. उनको एक्सक्लूड करके आप देखोगे तो वो 30% नहीं आएगा. It will come 10%, 5%. This is what happens. Right? This is what happens. So my point is that similarity सिमिलैरिटी चेक तो सॉफ्टवेयर कर देगा, लेकिन कॉपीराइट इन्फ्रिंज हो रहा है या प्लेजरिज्म वहां हुआ है एक्चुअल में या नहीं हुआ है, वो सॉफ्टवेयर चेक नहीं करेगा। लेकिन हमने अपनी कन्वीनियंस के लिए ये टूल्स बना लिए और इससे इनकन्वीनियंस हो रही है उल्टा। अब या तो टीचर बड़ा वेल रेड हो कि वो जब मनुस्क्रिप्ट पढ़े स्टूडेंट की तो तुरंत मेकआउट कर ले कि कितना काम इसने कहाँ से उठाया है, उसने उसकी इतनी रीडिंग्स वाइड हैं, वास्ट हैं टीचर की कि वो खुद से मेकआउट कर ले कि ये कॉपीड है और फिर वो अपनी इंक्वायरी करे इन दैट डायरेक्शन फर्दर। लेकिन हम क्या कर रहे हैं, टू सेव टाइम, टू सेव आवर एनर्जीज, सीधा सॉफ्टवेयर टूल में डाला और बोला कि साहब ये तो 20% आया है, लेकिन हमारी नॉर्म कहती है 10%। वो स्टूडेंट्स को हम इम्पोज कर रहे हैं, तू अनएथिकल काम कर, तू कोई ऐसे मीन्स अप्लाई कर जिससे वो कंटेंट जो है ना 10% आ जाए, बस हमें नहीं पता। तू लैंग्वेज को पैराफ्रेज कर, तू लैंग्वेज को डिस्टोर्ट कर, मैनूवर कर, थोड़ा मोटा मोटा उसमें इंटरट्वीकिंग कर लैंग्वेज की, अपने वर्ड्स में थिसोरस यूज कर या कोट यूज कर, राइट। ऐसे करके हम उसको बोलते हैं कि किसी तरह 10% ले आ, लेकिन वो भी एक्चुअल में मनुस्क्रिप्ट ओरिजिनल नहीं हुई, बिकॉज उसने क्या किया, उसने टू अवॉइड दैट 20% prohibition, he just either paraphrased certain things, rephrased some sentences, or to the most, or at the most, he had done something like thesaurus use कर लिया या quotes में डाल दिए paragraph, right, and so on and so forth. There are several ways which have been identified by the students nowadays. So you tell me now, is it ethical? No, it is not.
So, sir, it becomes the plagiarism becomes a subjective term, sir.
It is indeed, ma'am.
Good morning, sir. Good morning.
Yes,
May I
good
ask you
morning.
one question, sir?
Yes, Sujata ma'am, पूछिए.
I'm Sujata calling from Hyderabad.
Yeah, ma'am.
Sir, so many of the universities or colleges have their own respective journals, research journals and all that with IS and
Right.
ISBN. Right.
Right.
But do they follow some norms which are relate to the UGC? No, relate to the UGC norms and again peer-reviewed groups and all. Will they follow that? How far this when we publish in these journals and all, right? How far they're going to rate and relate to the CAS, maybe relate to the APS score and all? I would like to ask you. Would like to know, sir.
I see, Dr. Sujata, I have understood your question partially here. Because see, first you asked the journals which are being published by the institutions, do they have any norms or some standards to be followed, right? Was it your question, if I'm articulating it right? Do they follow
Yes,
certain
sir.
norms as prescribed by any body? So
Yes.
let me tell you that no body as such provides any such norms, right? The only thing is that usually these are ISSN, journals, right? In the case of the textbooks, these are ISBNs. So for that, they have some parameters to be followed and standards to be maintained. But University Grant Commission, or for that matter, any body, there is no such body which provides. I don't know whether the CARE has now come up with any standard or model to be followed, or model framework to be followed by these academic institutions while announcing the call for papers or while publishing the academic journals. CARE का मुझे डाउट है, वहां पे कुछ हो तो हो, लेकिन यूजीसी एज सच कुछ नहीं प्रोवाइड करती है इस पे। और ओनली स्टैंडर्ड जो अभी है ऑन डेट वो ISSN है। केयर का मुझे लगता है दे आर इन्वॉल्व इनटू द authorization or endorsement or listing of the journals, but even they have not provided with us any standards. But while coming into the CARE list, the journals are supposed to be peer reviewed, blind review, their previous editions must be available in some formats, or in the hard copy or in the electronic copy. We all have seen while applying for the CARE list, right? Our journals, we all academic institutions had applied for the CARE list. So those standards are there, but no standards are there to be strictly maintained or followed by the academic institutions while announcing the call for papers, etc. Sujata ji.
राइट। और एक बात है सर, मतलब व्हाई दे चार्ज 1200 to 1000, ऐसा कुछ भी मतलब चार्ज भी लेते हैं उन लोग पब्लिशिंग के लिए? मतलब पूछा जाता है कि एक पेपर के इतना पैसा
Okay.
आपको मतलब भरना पड़ेगा, ये होता है सर। बट हाउ फार यू कैन रियली ट्रस्ट वर्दी एंड ऑल, बिकॉज इट्स सो नो डाउटफul about this, that
See,
guarantee and all.
the issue is that the education sector in the country is highly ill-regulated.
Sir.
I being in the education sector, and we also have the same background, and we all are in the education sector. But let me tell you, it is highly irregulated sector. There are predatory journals charging rupees 5,000 or 4,000 from the authors to publish in the back date, or you may say to publish the work of the author at a very short notice, or sometimes even without the blind review or the double blind review, right? So those unethical things are prevailing undoubtedly because the sector is ill regulated. No laws, no sanctions are there, no regulations are there. And that's why these predatory journals and their owners are mushrooming. But after the enactment of this body called CARE, we certainly have now some check, right? If you want to publish, you always try to publish in a UGC CARE listed. Even if you see today, the UGC has come with the CARE, CARE listed journals, but while it advertises the post for the employment, it does not necessarily require that your work has to be published only in the CARE list. It writes that either peer reviewed or UGC CARE listed, right? But in the future, we may probably have only one category of publication, that is UGC CARE listed, right? So we now should always publish into UGC CARE listed journals, and that also keeps on changing because it is also ill regulated, being new, right? But in the future, we can hope for a streamlined aspect of it. Any other questions from anyone?
Thank you so much, sir. I think Rashmi ma'am also wants to ask some question. You can unmute
Rashmi.
yourself, ma'am.
सर गुड मॉर्निंग सर, गुड मॉर्निंग मैम। मेरा मैं रश्मि गौतम बोल रही हूँ कानपुर से। जी मैं आपसे सर एक क्वेश्चन था कि अगर कोई भी लेखक कहानी लिखता है या उपन्यास लिखता है, इत्तेफाक से उसमें जो नाम या स्थान वो किसी से मैच करता है, तो क्या यहाँ भी कॉपीराइट होगा? क्योंकि उसे पता नहीं है, जब उसने लिखा है तो एक इमेजिनरी नाम या कुछ अपने उससे नाम लिखे या स्थान लिखा कहीं पर कोई भी कहानी, और इत्तेफाक से मैच करता है। जैसे कि एक फिल्म आपने गुलाबी गैंग देखी, उसमें ये सारा जो है कॉन्सेप्ट आया था, बुंदेलखंड यूनिवर्सिटी का बना हुआ था। सर ऐसा कुछ इसमें भी कोई कॉपीराइट का है क्या?
नहीं, अगर देखो मात्र आपने नाम किसी का कॉपी कर लिया है
जी,
तो कॉपीराइट इन्फ्रिंजमेंट का क्वेश्चन क्लियरली अराइज नहीं होगा, क्योंकि वो सब्सटेंशियल कॉपिंग तो नहीं है मेरे हिसाब से। और आपने इन दिस केस इग्नोरेंस से किया है, बट इग्नोरेंस इज नो एक्सक्यूज मैम। रश्मि मैम, इग्नोरेंस कोई एक्सक्यूज नहीं है। आप ये नहीं कह सकते कि आई डिड नॉट नो वेदर सम ऑथर इन अमेरिका हैज रिटन समथिंग व्हिच आई एक्सीडेंटली आल्सो रोट इन इंडिया, राइट? This ignorance is not permissible, or it is not an excuse. एक बहुत फेमस अंडरलाइंग प्रिंसिपल है कानून का या विधि का या लॉ का कि इग्नोरेंस कोई एक्सक्यूज नहीं है, और वो हर लॉ में सेम तरह से एप्लीकेबल है। आप कहें कि मुझे नहीं पता था कि किसी को मारना मर्डर है, राइट? किसी को स्टैब करना मर्डर है, तो ये इग्नोरेंस इज नो एक्सक्यूज। तो यहाँ पे भी इग्नोरेंस नो एक्सक्यूज होगा। रश्मि मैम,
ओके, थैंक यू सर।
Anuradha ma'am, I guess I have exhausted my time. I also wanted to cover patents, but I will cover it tomorrow in my tomorrow's morning presentation, along with my co-speaker Dr. Victor Vaibhav Tandon. And I am hopeful, and I hope that our learned co-speaker Dr. Parikshit Sirohi has joined us. I had already sent him the link, or he may be joining us shortly.
Sir, he hasn't joined yet.
Dr. Sival, I'm here.
Yeah,
Dr.
Dr.
Ashwini sir.
Roy,
Dr.
namaskar.
Ashwini sir.
Parikshit, namaskar.
Namaskar.
Good morning. Welcome.
Thank you very much.
I will give you a brief, recapitulation of what all we have covered in 2.5 days of interactions with the learned colleagues. First of all, let me tell you the background of the audience here, Parikshit. We have excellent set of faculty members coming from Haryana and other parts of the country. We have people from Hyderabad, from Tamil Nadu, from UP, from Maharashtra, and predominantly from Haryana or the colleges of the Haryana, right? And on the first day, I gave them the cursory outlook or the outline of intellectual property, the different facets of IP. And on the same day, I also talked about in little bit details about different kinds of IP, right? And then academia industry collaboration and the challenges of academia industry collaboration. Then yesterday I had, we had excellent session by two of our co-speakers. One is Pankaj Tyagi, who is IP in-house counsel of Hero MotoCorp. He gave an excellent or wonderful presentation on trademarks, on GIAs, and also gave us the approach or perspective of the industry as to how industry takes the intellectual property, how industry takes the help of the academia in strengthening the links of academia and industry. Then Dr. Jayant Ghosh, he gave a presentation on IP policies for Startup India, right? So his presentation strictly revolved on startups, the policies relating to startups. And today morning, I gave them the presentation on fair use, on the use of the copyright by academic institutions, etc. Right? Instead of talking on trademark law, because on the first day we had to shuffle the session, right? Because of the absence of one of the speakers, right? So today you will be talking about the trademark, but since the basics of the trademark have already been discussed with the audience here, you have to tell us the industry perspective or tell them the industry perspective, or you may as to how you see trademark is of utility for the industry and for the academic institutions as such, or for their joint collaboration in future or in this context. Thank you very much to the audience for patiently listening me. I may be intermittently joining and going off and on here. Welcome, Parikshit. Over to you. Over to Anuradha ma'am, because she needs to introduce Dr. Parikshit first.
Thank you so much, sir. It gives me immense pleasure and honor to introduce second resource person of the day, Dr. Parikshit Sirhoi, who has taught the subjects of intellectual property rights, constitutional law, law of evidence, public international law, cyber law, competition law, business regulation, media law, and law of torts during the last 9 years. He has presented research papers at various seminars, workshops, and published articles in journals of repute and judged moot court competitions at various institutions across the country. He's sought after speaker and has delivered lectures at several prestigious institutions, including several national law universities and judicial academics of various states. He has been invited to deliver lectures at the Competition Commission of India, RCVP Norona, Academy of Administration Bhopal, Haryana Institute of Public Administration, Department of Science and Technology, Government of Rajasthan, and CBI Academy, Ghaziabad. He has been a visiting faculty of the LLM IPR program of the Maharaja Surajmal Bridge University, Bharatpur during the year 2017 and 20. An avid debater and sportsman since his school days, Dr. Sirhoi has authored a book titled Interface of Design Law with Copyright Law and Trademark Law. He has co-edited another book titled A Critical Approach to the Right to Information Legislation in India. He has also contributed book chapters to various national and international publications and is presently working on his book in the area of food security law. He currently teaches the subjects of intellectual property rights and constitutional law at Faculty of Law, University of Delhi, and was awarded his doctoral degree for his work on the topic Food Security Law in India, an endeavor to tackle the problem of hunger through legislation. He has worked as the teacher convener of the Moot Court Society of Campus Law Center, University of Delhi, and in this capacity successfully organized the Luthra Memorial International Moot Court competitions, which witnessed participations from teams belonging to 70 institutions in India and teams from outside the country. In June 2020, Dr. Sirohi successfully organized an international online seminar on reimagining the world post-COVID-19 pandemic. This program witnessed participation and paper presentation by around 200 participants belonging to 6 countries, 17 states and union territories across India. Sir, we are very delighted to have you with us. Dais is yours now.
Very much, ma'am. Thank you for the kind words. And thank you, Dr. Siwal, for introducing me to this wonderful group of academicians. I would like to, because, since a lot of these perspectives have already been covered by Dr. Siwal and in the previous sessions. I hope, ma'am, I'm audible.
Yes, sir, you are loud. You are audible, loud and clear.
Excellent. Thank you. Thank you very much. So I don't have any fancy presentation here because I did not know that the audience was teachers. If I knew that, I would certainly have made something. But I was under the impression that maybe it would be some kind of a mixed group involving students, etc. And I consciously avoid, especially during online sessions, presentations, because I feel that the audience is concentrating more on the presentation and less on what I'm saying. So, which is not a very happy situation. However, if required, I will certainly share a presentation via email on what I am going to talk. Over the course of the next 45 minutes or so, I am going to speak to you about the industry perspectives with regards to trademark law, and that is the topic which has been given to me during this particular session. And first of all, an introduction to trademark has already been provided. However, at the start of my talk, I will just begin by telling you that a trademark is a mark used in the course of trade. And the purpose is to distinguish the goods of one seller vis-a-vis those of others. It provides a link to the seller or manufacturer and the customer. So with this regard, the trademark law is also actually serving the purpose of consumers' benefit. So we seldom acknowledge it, but this is also one of the uses of trademark law, that the consumer benefits. The consumer knows that the goods are coming from certain source. The consumer knows that the goods are of a certain quality. The consumer knows that the goods are from certain reputation, and so on and so forth. Now, an industry, there are various ways in which an industry actually, any kind of an industrial organization actually benefits with respect to trademarks. It is not just the individual industry, but the consumer benefits, the particular producer benefits. Why? Because the producer is telling the person that, look, this is the link, this particular trademark, this particular shape, this particular packaging. So there is another concept in trademark law which we call trade dress. Many a times, more important than trademark becomes trade dress, because that is the first communication that the consumer has with the product, the packaging. Now, let me ask one simple question at this stage. You must have come across various trademarks in your life. What is the predominant color that you have seen? Most of the time, what is the most common color that you may have seen? Anybody? You can either give me the answer via text box, or you can give me the answer via just switching on your mic and giving me the answer. What is the most prominent color? आप लोगों ने देखा होगा ट्रेडमार्क्स अलग अलग कलर्स के होते हैं, ग्रीन होता है, रेड होता है, येलो होता है, so on and so forth. सबसे ज्यादा कॉमन क्या देखा है? Anybody? Dr. Siwal, of course, is not going to be, he's actually disqualified from answering this question. But
red color, Parikshit, red.
Okay, that doesn't count. But why is it so? Anybody from the audience? Why is the color red? Dr.
Sir,
Siwal has
red
given
color.
the answer.
सर गुड मॉर्निंग सर. सर रेड कलर बहुत इफेक्टिव होता है, अट्रैक्टिव होता है, इस वजह से उसको रेड कलर का.
बिल्कुल सही जवाब दिया आपने मैम.
Primary color, sir.
थैंक यू सर.
Yes, ma'am, you are also correct that it is a primary color. Actually, the answer lies in
Visible.
Yes,
So visible.
yes.
Yeah,
You're
visibility
absolutely
will be
right.
more eye-catching. Yeah.
Absolutely perfect. The answer lies in what? Yes, the answer is what Sujata ma'am just now mentioned. Actually, all of you are correct in various degrees. The answer is what you have learned in your physics class in maybe 8th, 9th standard, that the wavelength of the color red is the maximum. So that is visible from a long distance. सबसे ज़्यादा दूर से दिख जाता है. So that is why the color red is used for traffic signals, and that is why the color red is used for indicating danger and so on and so forth. The wavelength is the highest, frequency is the lowest. So that is why you will see brands use a lot of red in their packaging. Think of Airtel, think of Vodafone, now we, think of Ferrari. So you will find that all of them are using lots and lots of red. Maybe only that particular color, maybe in conjunction with some other color. Think of Akshay Kumar advertising red and white cigarettes. Again, very prominent. So at this point, I would like to just inform you that in India, we recognize single color marks only if they are written along with something else. We don't recognize single color marks. They are not capable of being registered. So just one color, one particular shade of red, one particular shade of orange, we don't allow it in. One particular shade of orange along with something written. Yes. Because what is the primary purpose of a trademark? You would have probably learned during your earlier session. The first purpose of a trademark is it should be distinctive. It should be able to distinguish that particular goods from those of other sellers, those of other manufacturers. Baki sellers se, baki manufacturers se. So if it is not able to achieve the purpose, the primary purpose of distinctiveness, then it will not be it is not capable of being registered as a trademark. Now in India, we do not feel that one particular color by itself. I hope I'm able to communicate to you what it means. It means that the color red, just simply red, along with the words maybe Airtel, along with the words maybe Ferrari, just one particular red and some words Ferrari, that is eligible for registration. But when we are using just one particular shade of red or one particular shade of orange without anything else, not capable of being registered. Whereas in other jurisdictions, Germany, US, European Union countries, they allow registration of such cases. Why? Because the primary assumption behind it is that they have attained certain levels of evolution, certain levels of education that the customer is able to distinguish. The purpose of distinctiveness is achieved even by having a single color mark, which is not the case in India, because the primary level of education in the people may not be that high level of education. And this is not only about education, the chances of a person being misled. So many times, even though we are highly educated, we may be misled. So this is where the industry is most concerned. So once a trademark is registered and the person starts getting misled, the trademark owner has actually two remedies. One is the statutory or the legal remedy, which is called infringement. Somebody makes use of a mark or something similar, milta julta, something similar. So let's say that slimline is a very popular mark for this thing, bathroom accessories, wash basins and stuff like that. Somebody comes up with a product called Seamline, SEEMLINE. Now here what is going to happen is that this is, if it is a registered mark, the trademark owner is going to suffer loss, because some people may be induced into believing that they are actually buying slim line and they might end up buying seam line. So this is the remedy of infringement is available. Now, other than this, it is also, there is one more remedy which is available, and that is passing off. Now, it is to be remembered that passing off remedy is available for everyone, irrespective of whether you are registered or irrespective of whether you are not registered. But infringement is available only to a registered trademark. So a registered trademark has two remedies, passing off and infringement, and an unregistered trademark has only one remedy, which is passing off. Now I have told you about infringement. What is passing off? Passing off is something which is based in common law. Common law is law of England. So this is based on that you have been deceived. Somebody has actually been deceived. So there is no statutory legal remedy is not there. So maybe a higher standard of proof may be required. So that is the advantage that is there for registration. I don't wish to go into more detail because the audience is not people from the law background, but this much is enough to understand how an industry actually benefits. Now, how do we make out that a particular trademark is actually a registered trademark or not? Somebody who is asserting that the trademark is registered will write the name of the trademark along with a small little R in the superscript, and the R will be enclosed in a circle. An R with a circle. That means it is a registered trademark. If you have applied for a trademark and it is not yet being given to you, you will put a small little superscript PM, which means you have applied for a trademark. The application is still under process of scrutiny. So this is the basics about when you are applying and when you are not applying. Apart from this, the industry actually benefits from something known as a well-known trademark. What do we mean by a well-known trademark? See, today commerce and industry and business, they are not bound by any geographical borders. You may find that trade is happening across borders. A particular product may not even be sold in India as such. A particular trademark may not even be registered in India, but you may have heard of that particular mark. Coming back to my example about Ferrari. Now, Ferrari does not sell its cars in India, but consumers in India are aware about this particular mark, Ferrari. So, even though it may not be a registered trademark in India, I'm just giving a hypothetical example, but it will still be regarded as a well-known trademark. Now, what is the test for this? How will you figure out whether it is a well-known trademark? Should it be well-known to everyone, every consumer of India, all 140 crore people in India? The answer is no. To a substantial segment of people who are likely to use that particular product, who are likely to have heard about that particular product. So let us take the example just to give this a little bit more. So coming back to the Ferrari car example, who should have been, and it is substantial segment of people. The law uses the word substantial segment of population. It does not say majority. Substantial. So the court may determine what is substantial. So now how are we going to be looking at this? So people who have the purchasing power, people who are interested in automobiles, people who are living in maybe urban India, maybe the metropolitan cities, maybe the tier 2 cities, whatever. So those kinds of things. So that particular, a substantial segment of that population should have heard of this brand, should have heard of this particular mark. Again, taking one more example, because this is an important concept. In our old trademark law, the law which was in force before 2003 actually, this was not recognized explicitly. It was recognized only implicitly. It was, the direct protection was not given to the concept of well-known trademark. But pursuant to the TRIPS agreement, Trade-Related Intellectual Property Rights Agreement, which took place at the Uruguay round in 1994, So this TRIPS agreement was finalized after this Uruguay round. So the intellectual property laws of all countries were modified accordingly. And this was a very important concept of well-known trademark, which actually was incorporated into the IP laws, into the trademark laws. And now the new trademark law, which has come into force from November 2003, makes an explicit mention of this well-known trademark. So just to clarify this concept a little bit more, because this is an important concept for industry, because not every trademark is registered in every country. It is a very expensive, time-consuming proposition. That is why they don't register every trademark in every country. But a Mercedes-Benz, a Ferrari, a Revlon, a L'Oreal, they will be enjoying protection of well-known trademark in India, even though they may not be explicitly recognized in India. Microsoft. So again, taking the example of, let's say, Revlon. Now, maybe the product is lipsticks. So now is it that all the people in India must have, just give me one moment, please. I'm extremely sorry. These are some of the perils of working from home, although it is very convenient, but these are certain perils. My apologies. So maybe if the product of Revlon is, let's say, lipsticks, now who is going to be the substantial segment of population? The substantial segment of population is going to be ladies, but is it going to include all the 70 or 69 crore ladies in India? The answer is no. The substantial segment of population with which we are concerned, in order to distinguish, in order to define this particular category of people who are going to be the test that, you know, whether the substantial segment of that particular population has heard of this mark or not. So it is going to be the ladies who have the purchasing power, the ladies who are likely to use these products. So it is going to be typically ladies in the age group of 15 to 59, living in urban India, and having the purchasing power, and those who are likely to be exposed to these products. So that is a substantial segment of that population is what we are concerned with here. Right? So now there are certain things which we have to keep in mind in order to decide as to whether a particular mark is a well-known trademark. And there are certain things which we are not supposed to take into account. So, for example, what are the actual number of consumers, or what are the potential number of consumers? So we have to actually take into account. Now, the number of people who may be dealing in those particular goods and services. What are the industry circles who are dealing with those goods and services? These are the things where we will be taking into account. And similarly, what are the things that are not going to be taken into account in order to determine whether it is a well-known trademark or not? So whether you have filed an application in India for registration? No, not relevant. Whether you have been using the trademark in India? No, not relevant. Like I told you, Ferrari is not selling cars in India under the brand name Ferrari. Okay. Hypothetically speaking, for my example, Revlon is not selling the lipsticks in India under the name Revlon. Okay, so these are certain things. So this is a very important concept in India, in the world, not just in India actually. And like Dr. Siwal mentioned, that you have been, I mean, previous sessions, speakers have spoken to you about geographical indications and trademarks and the basic introductions. So the economic value which is there is tremendous. And this is the whole rationale behind trademark law, as indeed all other IP laws, that the economic benefit should go to the person who has developed the IP. So what is the rationale? Why do we want to say that any kind of trademarks must be protected, or any kind of trademarks must be given protection? Why should the benefits only be confined to the person who has developed it or the person who owns the trademark? Actually, the answer can be found in the Bible. And the seventh commandment of Bible says, "Thou shalt not steal." So what will you not steal? The fruits of another person's labor. So somebody else has developed that particular any particular. So this trademark is actually providing a connection between the goods and the source of the goods, where the goods are coming from. So somebody else should not derive the benefit. You should not be piggybacking on the reputation of that particular person. So since my time is actually running out, I just want to confine myself to two more topics which I had prepared. And one of them is disparagement, which is very important for trademark. Now, you have a right to praise your product sky high. You have a right to say that, oh, my product is the best. You may have come across so many advertisements. See, because there is a very close link between advertisements and trademark. Because the trademark is actually going to be telling the person about the product. And what is the purpose of advertising? Advertising actually stimulates demand. Advertising creates demand. So by advertising, you are actually improving the strength of your trademark. You are strengthening your particular trademark. You are allowed to do that. You are allowed to say my product is the best. You will have found so many advertisements that this is the best toothpaste, this is the best car, this is the provides the best mileage, and so on and so forth. Everybody claims the same. Okay, and my product is the best. But while doing so, you cannot run down another person's product. You cannot show another person's product in poor light. Doing so will amount to infringement. Doing so will amount to damaging the reputation of the other person. So for example, if I am, let's say, Colgate, I cannot say that Pepsodent is bad. I can say Colgate is the best, but I cannot say that Pepsodent is bad. Okay. So, and in the FMCG space, fast moving consumer goods space, these kind of advertisements become the most important. Because you find here the competition is maximum for the eyeballs of the consumer. The consumer is concerned most with the eyeballs, with the the advertising, and a lot of the purchasing decisions are made on the basis of advertising. So again, to give you an example, which I often use in my class. Go back, I think most of you may have seen that, especially the colleagues who are from North India, may have seen this movie Gadar. There is a very iconic scene in that Sunny Deol, just pulls out the hand pump from the ground. And then he says that, he is first asked to sing praises of his own, of that particular country. So he is not very happy singing the praises of the neighboring country, but he actually does so. When he is asked to criticize the other country, that is his own country, then he does not do so. He refuses and he goes into a fit of rage and simply pulls the hand pump out of the ground. So that is something which an advertiser is not allowed to do. And the FMCG space is full of such examples and full of such litigation. Dabur and this one, Imami, Chawanprash, then cherry blossom and kiwi shoe polish. So you will find lots of such advertisements and lots of such litigation taking place that, this is actually not allowed. In fact, there is so much of matter which is there from the courts. So many court decisions are there that actually complete dissertations can be written on this topic, complete thesis can be written on this particular topic. But I do not, want to go into major detail because otherwise I will not be able to cover the last topic which I have. And that is with regards to the use of the mark improperly. Use of the mark improperly. Wherein, it is there may be certain conditions wherein you may have to use the other person's mark. For example, if you are an ancillary company or somebody who makes parts which are usable only in one particular other product. For example, let us say you are a person who makes headlights for Hyundai cars, Hyundai i20 cars. Now the same headlight is not going to fit any other car or any other model of Hyundai. Sometimes 2012 model of Hyundai Santro and 2013 model of Hyundai Santro, the accessories will be different. Similarly, somebody who makes car wipers, the same size wiper is not going to fit a Maruti Swift and Chevrolet Beat. No. So you will, in these cases where you are an ancillary person and your product is specially made or is something which is to be fitted only on one particular model, then you can make use of the other person's trademark. Otherwise, you can never make use of another person's trademark. This is one of the situations which I told you that you may use the other person's trademark. So, but for this, there are certain conditions which are essential. The goods have to be special. Your product has to be adapted to those particular goods. The product must be an accessory or an ancillary product. It must be absolutely necessary to refer to the other product's name. And without this, you cannot actually indicate that your particular product is there. Right. So if you are, let's say, XYZ wiper manufacturing company, so you can say that this wiper is fit for Maruti Swift. So you are using somebody else's trademark Maruti Swift. But like I told you, in such case, because the goods are specially made only to fit that particular car model, because it is an ancillary or accessory, and because it is absolutely necessary to refer to the other person's name, otherwise you are not going to be able to sell your product. So here, using the other person's name is going to be okay. But I will give you another example where it is not okay to use another person's name. So I think all of us are familiar with the shape of pressure cookers. What is the typical shape of a pressure cooker? Any of you, please? What is the typical shape of a pressure cooker which we find in our kitchen? Yes, please. Anybody?
Sir, participants cannot unmute themselves.
Okay. I was looking at the chat box actually, but I think nobody has given the answer. So actually, every pressure cooker is cylindrical in shape. And so if it is cylindrical in shape, if we go back, so all the pressure cookers that we find in our kitchens are typically cylindrical in shape. Yes, nowadays companies have come up with some different eye-catchy shapes also. But typically, or I would say 99.9% of the pressure cookers that you will find are cylindrical in shape. Now, if a product is cylindrical in shape, now if we go back to the maths class, elementary maths class, maybe 8th standard or 9th standard, the volume is going to be dependent on two factors. One is the height of the cooker and one is the radius, nothing else. In this situation, if I say that I have made the gasket is the rubber thing which is there at the top of the cooker, which keeps the heat inside. Safety valve also some people call it. So if I say that this gasket has been specially made for Hawkins pressure cooker, is that a correct situation? Friends, it is not a correct situation. I am not going to be allowed to use the mark of any other person. This will be infringement. In the previous example that I gave you, if I say that I am making the wiper for Maruti Swift, that is correct, no problem. But you can use, in that case, you can use the trademark of somebody else, that is Maruti Swift. But here, I cannot say that this pressure cooker is suitable for Hawkins. The answer is no. I cannot say so. Why? Because if I have made the gasket, which is round, it depends on a particular radius. And the same gasket will fit whether it is a Hawkins cooker, whether it is a Prestige cooker, whether it is a butterfly cooker, whether it is a Sunflame cooker, XYZ. Any company's cooker, it will fit. It will fit. The same gasket will fit all. It is not dependent. I cannot say that I have customized this gasket as per the requirements of Hawkins. No. I can say this gasket is suitable for all 5-liter cookers or all 2-liter cookers. So this is the case wherein it may in certain cases be permissible or okay to use the mark of somebody else, but in all other cases it will not be okay. Okay, so again to just revisit, it should be specially customized, specially adapted. It should be that product should be an accessory product for the other product, and it is absolutely necessary, because without doing so, you cannot actually sell your product. You cannot actually tell the people that, look, this product is there and it is suitable. So if I'm making, let's say, staple pins, can I say this staple pins is suitable for Kangaroo stapler, Kangaroo brand stapler? The answer is no. I cannot use the mark of somebody else, Kangaroo, because the same number of the same staple pin can fit any other stapler also, Camel stapler also. So it is not distinctive for that particular. It is not that that particular staple pins will fit only that particular stapler. In fact, staple pins are sold as per number 10 staple pin, number 12 staple pin, depending on the size of the stapler. Just like I told you about the gasket. So what is important is the size of the gasket, 2-liter cooker or 5-liter cooker or 1-liter cooker, and so on and so forth. So these are some basic principles which are relevant for industry with respect to trademark law. And that also brings me to the end of the content which I had for you today. I'll be very happy to take any questions if you have. Otherwise, Anuradha ma'am, it's over to you. Thank you very much.
Okay, sir. I'll unmute all the participants. And if there is any question, they can ask.
Good afternoon, sir.
Thank you.
Yes. Yeah. Good morning, sir. This is Sujata calling from Hyderabad.
Yes, ma'am.
Yeah, Dr. Sirohi, sir. Yeah, this is Sujata calling from Hyderabad. So I would like to ask one question. So now we are in pandemic time, and again, many products are visible on, we could say, the market on advertising on television, and digital market is huge. But how to follow this and believe it, their authenticity, because they have different trademark. Unless they have the trademark, we cannot believe it. Because and relate to the Ayurvedic, maybe even including the organic products and all. Then how is there any regulation is there observed by given by Ayush or maybe IFFAI? Is there are there any regulations, sir? Are they controlling?
You have come to a very important and very significant question, actually. And you can sell products without having them trademarked. It is not compulsory to get the product trademarked. But like I was mentioning during the course of my presentation, it is extremely advisable to get the trademark registration done, because the second remedy of infringement opens up. You can, if somebody is taking undue advantage of your trademark, you can put an end to it then and there. Now, with regards to the customer point of view, that the products being of a particular quality, etc., the important thing are something called what we call as certification trademarks. So all of these things that you find, ISI mark, ISO 9001, egg mark, FSSAI certification, they all come under the category of certification marks by the concerned agency. So you will find that BIS, Bureau of Indian Standards, they give a hallmarking for gold jewelry, that, you know, this much of purity is there, 22 karat gold is there, 23 karat gold is there, because otherwise the consumer will get duped. So they are testing it and then they are giving the certificate. Similarly, you will find many products, especially industrial products, maybe tires, maybe weighing machines, you will find ISI mark is there. So ISI mark is again issued by Bureau of Indian Standards, and this ISI mark shows that it is conforming to the mentioned quality standards. Again, FSSAI has become now mandatory for all packaged food stuff, whether it is bread, whether it is a packet of chips, whether it is cold drink, FSSAI certification is mandatory. Okay. So similarly for agricultural products, maybe, you know, your dals and maybe your masala, etc. So there is AgMark certification, AGMARK. So these are all things that we call as certification marks. So they also function as trademarks, but they are given on the basis of conforming to the minimum standards which are laid down. And similarly, you have ISO 9001, ISO 9002, depending on the kind of product category. You will be surprised, even trains now are given these certification marks. Railway trains, one particular train where the bed linen may be very clean, the toilets may be very clean, will have ISO certification, the others will not. The first train, if I remember right, to have ISO certification was Bhopal Express, which runs from Nizamuddin railway station to Habibganj in Madhya Pradesh. So now a lot of them, a lot of the others also have it. Similarly, railway stations have it. Similarly, so these are certification marks which help the consumer to know that these products are coming from a particular category. Just since we are all academicians, we must have heard of NAC ratings. What are those? They are also trademarks. This is an A+ college. This is an A college. This is an A+ university. National Institute of Eminence, national these NIE rankings. These are all functioning as trademarks only. I hope I was able to address your question.
Thank you so much, sir. Anyone else, if you want to ask question, you can ask directly to sir or put in chat box. आप अब म्यूट कर सकते हैं, आप सॉरी अनम्यूट कर सकते हैं अपने आप को एंड यू कैन आस्क द क्वेश्चंस. Thank you so much, sir. It was a nice and elaborative lecture, and if there will be any other question in the WhatsApp group or in the chat box, we'll let you know through mail. And now I love to invite my beloved friend Aanchal for formal vote of thanks.
Very good morning, one and all. It's a post the thanks. This under the pyramid scheme of UGC for M.D.S.D college. A heartfelt thanks.
Aanchal, आपकी आवाज ब्रेक कर रही है बीच बीच में. आप ऑडिबल नहीं हो, ब्रेक कर रही है आपकी आवाज.
Am I audible, ma'am?
Yes, you are audible now.
I will begin from the start then. A very good morning to one and all. It's my privilege to propose on this online national seminar on IPR organized by IQAC under the Paramarsh scheme of the institutes. On behalf of all M.D.S.D College, I extend a hearty vote of thanks to our honorable speakers, Dr. Ashwin Sival and Dr. Parikshit for their thought-provoking and informative sessions. Ashwin sir, you have clearly explained copyright issues, its management and uses in the academic institutions. Parikshit sir, you have covered various trademark laws through various examples. Thank you.
Thank you so much, Aanchal. And I am thankful to all the participants as well for bearing with us. And kindly, we'll meet again at 3 in the evening. You can fill the feedback form and meeting is open for next 10 to 15 minutes. Thank you so much, everyone. Those who have filled the feedback form, they can leave the meeting. Thank you, Parikshit, for being with us.
Thank you. Thank you.